That's all right. Hey, look, I do enjoy the sound of my amplified voice. If we could get all the members to log in so we can take roll as soon as we can, and we'll get this show on the road. For those of you in the audience today, welcome. This is the House Commerce Committee. I'm Kevin Vaughn. I'll be your chair today, and today's date when we log this in the annals of history, it's March 20. Stand by. March 26th, 2025. I believe, are we ready to go? Let's take the roll, Madam Clerk. Everybody dinner. Outstanding. Would you take the roll, please?
Mr. Chairman, you have 19 members present. You have a quorum.
All righty, super. Ladies and gentlemen of the committee, we got any personal orders this morning? We have a few. All right, we're going to start with Vice Chairman Bricken. We'll work our way from top to bottom here.
Thank you, Mr. Chairman. I would like to introduce my shadow today, a young lady from Jefferson City, Miss Daisy Watzel. So she's standing up, so make her welcome.
And I've got a personal order this morning. Germantown Surgery Center delivered Laura Vaughn Fisher, a sweet little girl, might be my granddaughter, back safely to her parents after a procedure this morning. So we just got word she's in recovery. Anybody down here working our way back over here, starting with Representative Burkhart.
Thank you, Mr. Chairman. I also have a shadow. Her name is Beth Young from Stewart County. That's her standing back. She stood up and sat down quick. She's a senior at Stewart County going to UT Chattanooga in the fall. Please make her feel welcome.
Chairman Keeson, did I see your hands up?
Yes, thank you. Thank you, Chairman. I would like to recognize, if she will stand, Harper Palvick, if you would. Beautiful Rutherford County, and she is here with Eagle Forum today. And thank you, Palvick. Thank you, Chairman.
Representative Vital, did I see your hand up?
Thank you, Mr. Chairman. I want to also introduce a young lady that's shadowing me today, Annabelle Casher from Beech Grove, Tennessee. And she's an 8th grader and a homeschooler, and it's her first time to the Capitol. So please welcome her. Thank you.
Representative Hemmer, did I see your hand up? Representative Barrett.
Thank you, Mr. Chairman. I have a couple today. First of all, I have to start with a family issue. My oldest daughter, Avery Elizabeth, turns 24 today. So I'll be having lunch with her today and just wanted to acknowledge and wish her a happy birthday. And then I have two folks that are shadowing me today. First of all, I would like to introduce Isaac Nemeth. He's a 7th grader homeschooler from Morristown, Tennessee, and this is his first time shadowing. Please make him welcome. And I'm also hosting Emma Gillum, who's a senior at Stewart County High School. She's from Indian Mound, Tennessee, and she's going to be attending Murray State in the fall.
Welcome to all our visitors today, and we hope you enjoy your time up here with us. Welcome in to the highest rated live stream committee in the Cordell Hall building. This week's episode will prove to be scintillating, and we hope that you'll catch us next week for our season conclusion. But first up, we've got to take care of the people's business, and right now I'm looking for Representative John Garrett with House Bill 0911. Sir, you've got a motion and a second. I believe there's also an amendment we need to deal with. What's your code over there? I'll tell you what, and while we're waiting for you to fire up a red there, we'll just ask you, you can nod if it's 006,000. That's right. All right, good to go. All right, let's get that amendment on there. Got a motion, a second on the amendment. All those in favor of attaching amendment number 1, which is coded 006,000 to House Bill 0911, please signify by saying aye. Any opposed, no. The ayes have it. Your bill is amended, sir. Let's talk about it.
Thank you, Mr. Chairman. Several years ago, I carried a piece of legislation that this committee, with this committee's leadership and the General Assembly passed, the Tennessee Information Protection Act. It's a small piece of legislation that protects your virtual you. It became effective January of this year. And with that large piece of legislation that took a couple of years to pass, there was some things we got to correct under public utilities, Mr. Chairman. That was under a definition for nonprofits, and some of our public utilities are actually for profit. And so that was under the exemptions, those that weren't subject to the piece of legislation. And so we're clarifying that to make sure it covers both for-profit and nonprofit public utilities that are exempt from this piece of legislation. So with that, Mr. Chairman, I'd be happy to take any questions, but that's all this amendment does.
All righty, super. Anybody have a question? Chairman Clemens, you're recognized.
Thanks, Mr. Chairman. Regarding section 4, with regards to the Attorney General being the sole party for discovery purposes in those actions, can you talk about the significance of that and the need for that?
Mr. Sponsor.
I'll be glad to do that. This, Chairman Clemens, thanks for that clarification. This started out a very different bill. Now, that is not part of this amendment. That's not part of this piece of legislation. That will be something we may bring back later on, but that portion of what you're seeing is an old amendment. The amendment that we just put on, the one ending in 6000, rewrites the bill and only does what I just described. It has nothing to do with the Tennessee Consumer Protection Act as it relates to the Attorney General and what it started out as. This bill only is what the amendment is before you that's part of House Bill 911.
Thank you.
Chairman Clemens, you got access to dashboard so you can catch that?
I've got it here. I didn't know I rewrote the whole bill.
Okay,
Thank you.
all right. Anybody else have any further questions for Representative Garrett? Seeing that everyone here appears to be fairly knowledgeable on this subject matter, we will put it up to a vote. All those in favor of passing House Bill 911 to calendar and rules as amended, please signify by saying aye, or you can press the green button. Madam Clerk has got there. So I'm going to say nodding is acceptable too. But let's just get that green button or red button. We don't judge around here which color palette you choose. All right, Madam Clerk, you take the roll. Take the vote, please.
Mr. Chairman, you have 21 ayes, 0 noes.
All right, you're off to calendar and rules.
Thank you, Mr. Chairman and committee.
Good morning, Representative Hawk. We're ready to talk about House Bill 965, if I can get a motion in a second, and I just heard those. So, sir, you are recognized on House Bill 965.
Thank you, Chairman and members. Tennessee is booming with construction right now, and we need folks to help do the construction work. This is a bill that simply encourages bidders for state contracts of $1 million or more to use apprentices. It puts a question in there. It's a very permissive piece of legislation, but in hopes we get more folks to go into this field of work to build what's necessary to help us grow in Tennessee. That's it in a nutshell, Chairman and members.
Thank you, sir. I can tell you from firsthand experience, trades and craftsmen are sorely needed, and it's a very successful pathway to prosperity in our state these days. Do we have any question on this bill for Chairman Hall? Seeing none, we'll vote on it. Madam Clerk, would you load the board for us? Everyone cast your vote. Anybody need to change their vote? And if our latest members could please log in, that would be great. All right, we're squared away. Madam Clerk, could you tally the score?
Mr. Chairman, you have 23 ayes, 0 noes.
All righty, thank you very much. Chairman Hawk, House Bill 965 is headed to calendar and rules.
Thank you, Chairman and members.
Now then, let's talk about House Bill 962 while you're here. All right, you're in proper posture. We've got an amendment traveling with that. It's amendment coded 006085.
That is, and the mandatory language comes from your brain. I was going to say your office, but it's actually your brain that has come up with that. And essentially, we spoke about this bill a little bit last week and wanted to get just let it simmer for a little while. The amendatory language that you're adding allows us to permissively set up a local government's CBD board, much like we've got other boards that are set up with local governments to help either the Department of Ag or the ABC, should a piece of legislation go forward, to help enforce the hemp laws and rules that are on the books. It's something that the state agency would have to sign a letter of understanding with the local government to be able to do this. The amendatory language that you've got, Chairman, actually adds a section in there that would create an appeal process that was more defined than one of our members asked last week. So it gives a more defined appeal process to it. But just some wordsmithing on the amendatory language. Happy to adopt the amendment if the committee so enjoys to do that, and discuss the bill as it's amended if the committee chooses.
Let's get that done, and then we'll talk about the bill. I'll explain what my issues were and how they've been addressed through this. But if let's take a vote on attaching amendment 6085, which is logged in as amendment number 1. Let's attach that to 962. All those in favor, please signify by saying aye. Aye. Any opposed, no. All right, the bill is amended. And y'all, last week, it's one of those deals where you know how when you're running and all of a sudden you blow out your hammy and you got to stop. That was kind of the way my brain was working in here last week when we started talking about this. And I realized that I was generating more questions within my thought process on this than I was comfortable with. And so I didn't want to, I served my entire time here with the sponsor. I know he's a smart fellow. And so when I punched the eject button last week to let's work on this, I started talking with the sponsor and also some of the departments and talked with our legal team here. And here's where we're falling out is that we all know that, or some of us know that our leader is bringing forth a regulatory structure for the CBD industry, for the hemp industry. And under that scenario, enforcement will be led by the state. But in the meantime, if that does go a season, that if something happens to that bill and it does not get approved, then we have seen that our Department of Agriculture is struggling with regards to enforcement of rules and laws around the state. And so what we did was we broadened the reach of this to where this will serve as a stopgap measure for local communities to be able to enforce state regulations within this product type, if they make arrangements with the state and operate under an MOU that they have. And I think it's, one of the phrases that we hear around here is belt and suspenders. You're doubling up, but in some cases, this may be only a belt, given the way that we're moving forward. And when we see all of the licensees, and the sponsor can speak to this, the tremendous number of licensees that we have for this product in the state, this will allow our local folks to prepare themselves to assist with the enforcement of state law in their community until we get this product and this situation better regulated. And I think that was the intent of it. And I actually am really big. I started to say, no, I'm not going to say that. I'm encouraged by this piece of legislation. I think it's something that's sorely needed in case we don't see things progressing the way that some people think they're going to. So anyway, with that, I'm sure the sponsor will answer any questions. Leader Cochran.
Thank you, Mr. Chairman. And sponsor, just one quick question. I saw, so toward the bottom of page 2, 43-27-304. So it says the local law enforcement agency of a local government that has created one of these boards may enforce this chapter and any ordinance or resolution of the HDCP board. One just kind of follow up to that. So even though this chapter maybe doesn't mention let's say a distance requirement. So in the same way like beer boards have a distance requirements, maybe from a church or a school. Would this local board have the ability to put that type of requirement in, or since that's not specifically mentioned in law, they wouldn't be able to?
Mr. Sponsor.
Thank you. At the moment, my vision for this legislation only enforces what's in state law. Local government becomes an arm of the state enforcement on this particular issue. Should the state move forward with distance requirements, requirements of numbers, population requirements, things of that sort, then I would envision that would be enforced. But at the moment, the way the bill is at the moment, it only allows the local government to enforce what is currently in state law.
Okay, thank you.
And Leader Cochran, it's my understanding that there's nothing in any of the state legislation that prohibits local governments from passing zoning ordinances and a use table that includes these. So from that standpoint, I think that they would still have the same local control over land use.
Mhm.
And with these facilities or these retailers having to comply with their land use laws.
And
Leader Cochran.
and this might be just a little clarification, and I'm fine with it, by the way. Like I have no issue with this at all. It would just on item 1 there where it says enforce this chapter and any ordinance or resolution of the HDCP board. That it was that and that kind of made me think, well, maybe the local would have the authority to set up distance requirements. But thank
Okay.
you. I appreciate
Yes, sir. Chairman Lafferty.
Thank you, Mr. Chairman. I see in here, it talks about the requirement of a permit. And I understand with the other bill that's moving would also require permitting. It almost seems to me, and tell me if I'm off base, it almost seems to me like we're using the structure from the ABC alcohol permitting, and we're using a structure from the beer permitting at the local level. And we're kind of dropping both on these businesses. Could you help me straighten that out,
Chairman Hall.
please?
Can I ask you a reference to the beer permit
Chairman Lafferty.
situation?
Let's see. I am 4327-303, subsection. Oh, I had it a second ago. B1, requiring each retailer of HDCPs to obtain a permit from the board authorizing the sale of such products at each retail location.
Mr. Sponsor.
And if I could, just to address, I used the analogy of a beer board last week in discussion, and that's what local governments asked me to look into, was a similar type structure as a beer board, with a fee that's associated with it to help enforcement therein, if there's local cost in order to do the enforcement. There is a permit, but it's not a redundant permit. Well, let me back up a second. If someone in an establishment sells beer and hemp, then they need, yes, a beer license, and yes, a hemp license would need that. If someone sells other intoxicating products, then yes, they would need that permit from the ABC as well as a hemp permit. So there is a specific hemp permit that is needed that would be separate and distinct from other permits should they sell on those intoxicating items as well.
Chairman Lafferty.
Thank you for the response. Thank you, Chairman.
Mr. Sponsor.
Chairman, if I could, I've still got Leader Cochran's question dancing through my brain right now, and I don't want to give an incorrect answer or a vague answer in that. I think that Chairman Vaughn did step in and assist me in answering that question. Should local ordinances come about, then they would have an opportunity to enforce those as well. I see this as being local government in concert with either the State Department of Agriculture or the ABC, whomever takes primacy on that. So I feel like I did not give you I don't know if accurate is the right word, but I did not give you clarity in that. But a local ordinance can come about, but it is in concert with what state law has in effect.
And as we look at this too, and the intent is that we're not challenging the primacy of the state regulations and the state law, whatever comes out of the other bill. But I think it is, what appeals to me about this is the fact that this may be the only regulatory, we may serve a period of time that this is the only regulatory body that deals with these products. Mr. Sponsor, and then I've got some other folks for questions.
And thank you. To that point, if the leader's bill does go forward, looking at the responsibilities of the ABC, thinking Office of Courts there with the ABC right now, and I'll use Greene County. I'll use my home as an example. 6 liquor licenses to sell liquor in the state of Tennessee or in Greene County. There are 45 permits for hemp in Greene County right now. So it is substantially more and more regulation and more work for the ABC to conduct. So this may be one of those partnerships that even the ABC chooses to utilize with local governments as well. Just wanted to bring that point out, Chairman.
Thank you for that clarification. Representative Lynn, did you have your hand up?
I did. Thank you, Mr. Chairman. I really like this. I think it's a great compromise. The bill the other day, I was a little apprehensive about the amendment. And so I really think this is a great compromise, and I think it will help our local government. So I feel much better about what we're doing. So thank you for bringing this.
Thank you.
Representative Hardaway, I saw that hand shoot up.
Yes, sir. And I want to thank you for prompting these questions. Okay. Actually, I'm joking, sponsor. He did clear up a lot of things for me.
Well, your comments from last week, Leader Hardaway, helped us work on the mandatory language. So thank you for your comments last week.
All right, thank
Representative
you.
Hardaway.
And thank you, Mr. Chairman, seriously, thank you for your summation earlier.
All righty. We have any other questions or commentary to offer today? If not, let's vote on this. Madam Clerk, would you load the board? Let's take the tally on this. Everyone cast your vote. If you need to change your vote, please change your vote. All right. Let's count up the score, Madam Clerk.
Mr. Chairman, you have 20 ayes, 0 noes, and 1 present not voting.
All righty. Well, Representative Hawk, 962 is headed to Finance as amended.
Thank you, Chairman, members.
All right, folks. House Bill 470 has been taken off notice. Now then, we're going to recognize one of our own. Chairman, 342 is off notice?
Yes, sir.
House Bill 342 is off.
No.
I was going to say.
Motion on the bill. Motion, excuse me.
Woo! I was reaching for the gavel.
Yes, sir, I know.
I was going, wow, this is some late breaking news. All right.
Okay.
Just in case you ever think it's scripted up here, folks, we are not scripted.
Really?
All right.
Thank you, Mr. Chairman. And Mr.
Chairman Moon, you're recognized on 342, and I see you have an amendment to offer.
Yes, sir, Mr. Chairman. It's 4247.
Motion on the amendment.
All right, folks, everybody like to get this in proper posture. You would like that attached before we begin conversation, wouldn't you?
That's correct,
Chairman?
Mr. Chairman.
All right. All those in favor of attaching 4247, please signify by saying aye.
Aye.
Any opposed, no. Hearing none. Your bill is amended, sir. Let's talk about the amended version of House Bill 342.
Thank you, Mr. Chairman. This legislation addresses veterans' disability claims process. Currently, the VA benefits claim system is extremely complex and difficult to navigate, not to mention the extensive backlog of claims still waiting to be processed. Today, if a veteran is planning on filing a claim, they may do it in one of 3 ways. They can do it completely on their own. They can work with a free service such as their local veteran service officer or a accredited member of the VFW, DAV, American Legion. 3, they can turn to free market and work with an unaccredited paid expert company. Federal law states that no individual may act as an agent or attorney on behalf of a veteran and charge a fee to do so. Being accredited means they have power of attorney or are authorized to represent that veteran with the VA. There are currently no federal or state laws against unaccredited individuals advising or consulting with the veteran for a fee on how best to file a claim on the veteran's behalf. And that is what these for-profit companies do. They do not have power of attorney. They do not work, nor do they speak with the VA on the veteran's behalf. Now, while this is a much needed service and there's many companies that do great work, there's several bad actors in this space, and they're taking advantage of our veterans. This legislation is essentially a consumer protection bill. This bill preserves a Tennessee veteran's constitutional right to choose their representation while also protecting them from unfair practices by introducing common sense guardrails to uphold ethical standards, enhance accountability, and protect veterans from exploitation and fraudulent and misleading claims. Some of these guardrails, common sense guardrails in this bill include mandating that all fees are contingent upon a successful outcome and are one-time only fees. Prohibits non-refundable fees, upfront fees, referral fees. Mandates disclosure of the free options available from the county service officers and other congressionally non-chartered organizations. They restrict from taking a veteran in during their first 365-day presumptive period without a notice and a waiver from that veteran. Prohibits overseas call and data centers for processing veterans' personal information. Background checks required for employees. Adds civil and criminal penalties to anyone who violates these rules under the Consumer Protection Act of the state of Tennessee, which would be enforced by our Attorney General. This bill is not trying to replace free options or put down veteran service officers or those that are accredited by congressionally chartered nonprofit organizations. We are simply adding another option to the list for veterans and ensuring that they remain accountable. In closing, this is currently a completely non-regulated industry that demands regulation to protect our veterans. Thank you, Mr. Chairman.
All righty, thank you, Chairman Moon. And hey, just if y'all would indulge me a moment, I know that Chairman Boyd and Chairman Moon both served our country. Do we have any other veterans that members of the Veterans Caucus here other than you two? Anyway, yeah, that's what I said, Chairman Boyd and Chairman Moon. So I know Leader Camper's not here. She served honorably as well. So anyway, thank you. All right, so folks, we've got, you're in for a treat today. Somebody has traveled all the way from the District of Champions to weigh in on this bill. My good friend Justin Johnson is here to offer his thoughts on the bill. And Mr. Johnson, if you'd come up, and we're going to control the microphone. There's no buttons or anything you got to push. And what we would do is we would ask you to provide your thoughts on this bill in 3 minutes or less.
All right. Thank you, Chairman Vaughn.
And if you'd give your name and address for the record.
So Justin Johnson, 1037 Moorfield Road, Collierville.
Time out. I've got to do something procedural here. We're going to go out of session before we hear this testimony. Now you can go back, and that didn't count on your 3 minutes.
Justin Johnson, 1037 Moorfield Road, Collierville, Tennessee, representing Shelby County, but also representing Collierville Veterans of Foreign Wars, Post 5066. I come before you today as a combat veteran and a representative of Tennessee veterans that have not had a voice in the concerns of the SAVE Act. After the passing of the PACT Act in 2002, it added $280 billion in benefits for veterans exposed to toxins. The truth became sadly apparent. The tax dollars attached to veterans became more important than helping veterans. Veteran services in Tennessee was not fully staffed with service officers to handle veteran disability claims in a fast and efficient manner. This has been the case all around the country, in which VSOs are overwhelmed with veterans reaching out for help. This delay has risen an underworld industry of private veteran claims companies that assist a veteran in filing a disability claim in return if they are granted a percentage of the veteran's disability claim. Federal law has made it a crime for anyone that is unaccredited to charge a veteran for a fee for advising, assisting, or consulting. The dilemma is that Congress removed the criminal penalty in 2006, making the only punishment a strongly worded letter from Veterans Affairs. These illegal claim companies are known as claim sharks. The SAVE Act is being introduced to state legislators across the United States, attempting to make it legal for claim sharks to operate openly in states in direct violation of federal law. The SAVE Act will open the floodgates for illegal claim companies to operate in Tennessee. The only individuals that can legally help a veteran file a disability claim are accredited veteran service officers and attorneys. I recently had a conversation with the Tennessee Department of Veteran Services, and they advised me that they have an 80% success rate with helping veterans filing claims. The Tennessee Department of Veteran Services stated, if the SAVE Act is passed, they will have a difficult time retaining quality VSOs, as they will not be able to compete with the wages offered by private companies. The Tennessee Department of Veteran Services was told to defer from weighing in on the SAVE Act. Why would you not allow the subject matter experts on veterans in Tennessee to testify to something that will financially impact Tennessee veterans? If the SAVE Act is passed, I am certain it will negatively impact veterans, as unaccredited, for-profit, and unregulated companies will aggressively pursue veterans to file for benefits, and veterans will unknowingly sign away their earned benefits, believing it is their only option to receive help. Furthermore, the SAVE Act opens veterans to fraudulent claims and puts all the responsibility on the veteran and not on the claim sharks. Accreditation for VSOs and attorneys protects the veteran. We should want the highest standard for our veterans and the American taxpayer who is funding the disability claims. A veteran receiving help should not be put into debt. Hasn't this country asked enough from our veterans? Please do the right thing for our disabled veterans and keep veteran services at no cost. Tennessee veterans deserve better than what the SAVE Act is offering, and I hope you will not let the predatory legislation pass out of committee today. Thank you for the opportunity to speak, and God bless America.
Thank you. Thank you for traveling up here to share your thoughts today. Do we have any questions for Mr. Johnson? Any questions for Mr. Johnson? Representative Powers.
Thank you. And thank you, Mr. Chairman. And thank you for coming here and your service to our country. The question I did have, you were talking about the federal law that was passed, and now there's no penalty at all for that. Do you know why they took the penalty off, or what the reasoning was behind that federal law? That
So
Hold up, Mr. Johnson, wait till you recognize. I know this is an odd setting, but this is the way we keep order up here. So you're recognized, sir.
Yeah, thank you, Mr. Chairman Vaughn. So the notes for that, they kept them closed and private, so we don't know the reason of the Senate. My personal belief is when it was passed in 2006, the Iraq War kicked off in 2003. So it was going to be a large cohort of disabled veterans where benefits to attached. And I personally believe there was some lobbying to remove that. So we would get to this point because there is billions and billions of dollars attached to veterans. And so I think it was to create the problem that we're in right now.
Okay. Just one follow-up.
All right. Got a follow-up there?
Yeah, I have a follow-up. Thank you. The other thing that you mentioned, this law that the bill rather is kind of geared toward the people that are already working out there that they're unaccredited. So right now, I know there's probably a lot of that going on currently. Would you not think this bill would help prevent some of the ones that are unaccredited, people doing it online and other things that they have to contend with?
Mr. Johnson, you're recognized.
So like anything in Tennessee, if you cut hair, if you're a mechanic, if you build a house, you have to have a license to do that. The only way this bill will protect veterans, and they don't want it, is for them to be accredited. There's a pathway like everybody else for them to become accredited, because they don't want to be accredited because then they'll have to fall in line with the standards that every other service officer falls in place to.
Thank you. Okay. Representative Chairman Haley, see you down there?
Thank you, Chairman. So, okay, these groups are these people that are providing outside of a VFW or local service representatives. How do you consider this bill to be predatory when it's setting up safeguards and guidelines to protect that they don't get paid anything? They have an option. They can wait and get an appointment with the service officer, or they can get an appointment with VFW as yourself. If they choose to use one of these other unaccredited people, but yet they don't get any fees up front or anything, and the protections that's put in this, how do you consider this to be predatory?
Mr. Johnson?
So let me just correct a couple of different things. Far as your veteran service organizations, the VFW and American Legions, they offer additional accreditation to service officers, but the majority of them that are VFW and American Legion qualified are going to be your county and state veteran service officers. So they just receive usually additional 40 hours of training on top of the mandatory 40 hours. What this is doing is this is basically hoodwinking and green lighting for the claim sharks to operate in Tennessee, that they will not face any prosecution. The adjutant general or the big district attorney in Texas, Ken Paxton, he already has a federal legislation pending against Veterans Guardian that is actually behind the SAVE Act. So there are AGs across the country going after them. The problem is that these groups are making millions and millions of dollars, and they're very well funded. And every time it comes up before the Senate and Congress to vote, they stall on it. But there is the GUARD Act that is in place with Congress. And what the GUARD Act would do is reinstate the penalty, and it would allow the DOJ to go after these bad actors. And so that's the reason we're against it, because we believe, because this will directly impact combat veterans. If you serve your country and you fought in the wars that we have, you shouldn't have to pay to receive your earned benefits. I mean, the sad thing is I'm sitting in my VFW meeting in Collierville the other day, and I'm talking about going up here, what the claim shark is. And there's a Vietnam veteran that's sitting across from me that fought in the Tet Offensive. And he says, I didn't know that it was illegal. I've got 7 more payments to go before I'm done paying my claim agent. And that's not what we want. We want, because all this is money, but what it really does is this is your direct access to benefits. There's only 2 ways that you get VA healthcare. You make underneath a certain amount of money, you're basically poor, or you have a service connection. And that service connection comes through the veteran service officer. And all we're saying is they have to have the same standards that everybody else has to. Because you probably wouldn't want somebody to build your house that didn't know how to build a house, would you?
You got a follow up there, Representative Hale? You good?
I'm good.
All right, thanks. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman, and appreciate you coming today, and thank you for your service. You know, as I look at this, and I'm listening to you talk here, and I've talked to Chairman Moon, his office is right next to mine. It seems as if when this was decriminalized or the penalty was taken away at the federal level, that it's kind of become the Wild West out there. Mm-hmm. And so I agree. Our veteran service officers at the VA, the ones that we have here at the state, and even in Wilson County where I live, they do an incredible job. And I have actually had veterans that I've linked up with them, and they've been able to help them out. But it seems like what Chairman Moon is doing here is actually tightening this up. He's putting some guardrails in place. So if you think that there's some unscrupulous actors out there and this thing needs to be cleaned up, it seems like this bill is taking us in the right direction. And I want to speak on a personal level. My father was a Vietnam veteran and had some service-connected disabilities, and he went to his VA officer back in the 1970s, and they kept giving him, we've lost the records. There was a fire. That was the excuse that they used for years. There was a fire. And he finally gave up on it and just went to work and did his thing. But when he finally retired from his civilian job, and he retired early, he was a firefighter. When he retired, he took it on himself, and he got the records, and he fought and went back and forth, and he finally was able to prove his service-connected disability and fill in the gaps of those missing records. And I think about him, he could have really used some help from one of these organizations. He would have been willing to have given up a small portion of the benefit up front to get some assistance and put in his packet together. And so I don't have a problem with this at all. I think this does two things. These companies out there oftentimes help veterans fill in the gaps of missing records and help them when they're going to talk to their Veterans Affairs officer. But the other thing that it does is you've mentioned this, and I've heard the horror stories out there about these companies that are doing this and exploiting veterans. And so I'm proud that Tennessee is standing up, and we're putting in place some state legislation that would put some guardrails in place and protect our veterans. So I'm supportive of the bill, Chairman Moon. Thank you.
All righty, thank you. Does anyone else have any other questions for Mr. Johnson? If not, thanks for being here today. Thanks for your testimony. And we appreciate you being here. And we've got someone else that's also going to testify with the bill. Thank you for being here. And next, we're going to have Mr. Peter O'Rourke come and sir, if you could share with us in a 3-minute dissertation, your perspective on the bill. Introduce yourself and where you're from.
Thank you, Chairman Moon, or Chairman Vaughn. Chairman Moon, thank you for bringing the bill. My name is Peter O'Rourke. I'm the president of the National Association for Veterans Rights, and from Tennessee. Grew up in Cookeville, graduated there, and also graduated from the University of Tennessee. And it's great to be back. You just heard a lot about this bill, about the situation for veterans getting their service-connected disability payments, and had some questions. And I'm here to answer any of those questions, but I do want to correct a few items. One, just because they are one of our members of our association and a company that I've personally evaluated and ensured is ethical, transparent with their operations, and that's Veterans Guardian. And you heard that they were under a lawsuit, I guess, in the state of Texas by the Attorney General there. That is incorrect. The company in Texas that is being pursued is a company called VA Claims Insider, and that company is not a member of our association for good reason. There are bad actors in this space. I've been at the Department of Veterans Affairs as the acting secretary, as the chief of staff, and I've worked these issues in claims since 2007. And you've heard about 2006 with criminal penalties being removed from this process. And I would inform the members here that was not due to the Gulf War. It wasn't due to backlogs. It was actually due to a crisis in assistance for veterans. If you go back to 2005, you'll find that there were very few, if none, accredited representatives because there was a criminal penalty associated with your performance in that area. Once those criminal penalties were removed, you saw many more attorneys and claims agents that were willing to become accredited by the department and fulfill that role for veterans, and that was a good thing. In 2013, we had another crisis at the VA. That's kind of a theme there, and it was a large backlog of service-connected disability claims, a lot due to an extended period of war. And the department, in its wisdom at the time, decided to create a fully developed claims process, really providing the veteran their opportunity to do their own claim. And that's what you've heard today. And that's really the most relevant part to this legislation, because that provided an opportunity, a pathway for veterans to be able to do their own claims. That was originally thought of as a collaboration between the veteran service organizations and veterans to work together outside of the VA development system to then be able to submit their claim. It didn't really work that great. It's not something that was heavily utilized, but it did open the door for veterans to take charge of their own claim. And then you saw this whole period where you have this other industry that got developed and started providing assistance. When you push $140 billion at the door each year in these kind of payments, you're going to have bad actors show up. And they did. and they've been operating on both sides of the spectrum, either providing fraudulent claims, providing veterans with a 100% service-connected disability when they did not warrant it. And then you had others that decided they could very, very much help veterans navigate this complex process and get their claims done correctly.
Thank you, Mr. O'Rourke. That concludes our statement period. Does anyone have any questions for Mr. O'Rourke while we've got him here? I see Leader Cochran is I can tell he's got an inquisitive look on his face. So, Leader Cochran, you're recognized.
Thank you, Mr. Chairman. And so if you wouldn't mind just to clarify one more time. So essentially right now we have maybe an environment where where the bad actors can take advantage. Could you maybe delve into that a little bit more? How this legislation could perhaps maybe reduce some of the bad actors who are currently maybe taking advantage of our veterans?
Mr. O'Rourke.
Thank you, Mr. Chairman. Yes, absolutely. And that's been something that we have really been working on for the past 2 years, is try to differentiate between the companies in the space that actually are doing their best to try to serve veterans and those that are doing their best to serve themselves. As from our perspective for the association, we developed a comprehensive list of what expectations a veteran should have and bad actions that should be looking out for. And this bill represents those bad actions that we've identified in this space, put them into regulations so that we can do this both at the federal level and at the state level.
Leader Cochran.
And then just one follow-up. So with your understanding of our state law currently, would it be your opinion that currently there's really not a lot of enforcement at the state level to prevent the bad actors currently, and perhaps this would put in a safeguard against them? Is that an accurate statement, or
Mr. O'Rourke?
Yes, it absolutely is. There are no regulations that to govern this area at the federal or the state level.
Thank you. Thank you very much.
Thank you. Anybody else have any questions for our guest? Seeing none, we will go back in session. Thank you for your time and your testimony as well. So we're back in session. Chairman Moon, you're recognized.
Thank you, Mr. Chairman. I stand ready for any questions. I do appreciate the testimony, especially from my comrade from Collierville. It was well done, sir.
All righty. Anybody have any questions for the sponsor? Speaker Marsh.
Thank you, Mr. Chairman. I wanted to read a short text I just got from a veteran. Said these for-profits can be great if done right. The nonprofits have let veterans down. They're almost no help when you go to them. If they do help, it takes forever. So I think that this is a good bill. Thank you.
Thank you, sir. And I think wherever you fall on this issue, I think everybody wants the best for our veterans. And whenever you have folks that are diametrically opposed, it's a difficult choice to make. But appreciate you bringing that perspective into this. Anyone else have any questions? Chairman Clemens.
Thank you, Mr. Chairman. I appreciate it. I didn't really have a question. I just think that, this is a difficult issue, and I know a lot of veterans are impacted different ways by this, and I appreciate everybody's opinion, but I don't think we can overlook the important work that the VFWs do. So I just want to recognize, and I think this entire committee would recognize the important work of the VFWs. So thank you, Mr. Chairman.
Thank you, sir. Without a doubt, I know that my friend from Collierville and his cohorts have resurrected a long dormant post and are providing services and opportunities for our local veteran community there. And so we are, all of us stand in support of that. Anyone else have any questions, any thoughts, any comments that they want to share with anyone? Well, then it looks like it's time for us to vote on this issue. Unless there's objection, I seeing none. Madam Clerk, would you load the board and make it available for voting? Everyone cast your vote? Anyone wants to change their vote? All right. Voting is closed. Madam Clerk, would you tally the vote?
Mr. Chairman, you have 19 ayes, 0 noes, and 2 present not voting.
All righty. Sir, you are on to calendar and rules as amended.
Thank you, Mr. Chair. Members.
Chairman Bricken, you're recognized with House Bill 922. Motion and a second on it. We've also got an amendment traveling. Would you like for us to amend this now or amend this later?
Let's do it now because it makes the bill.
Oh, that's even better.
4585.
Got a motion and a second. All those in favor of attaching the bill, please signify, attaching 48585 to the bill and rewriting it, please signify by saying aye. Any opposed, no? The ayes have it. You're amended, sir.
All right. Thank you, Mr. Chairman and fellow committee members. This is a consumer protection bill. It adds an item to our consumer protection legislation that says if someone calls a citizen and tries to claim they're involved in a lawsuit and then extort fees to get them out of the lawsuit, it is a consumer protection violation, and the AG would go after them. So that's what the bill does.
Thank you, sir. Do we have any questions for our sponsor? Any questions for our sponsor? Seeing none, I don't believe anybody would object to a vote on this then. Madam Clerk, would you load the board for us? Everyone's vote is cast. Anybody want to change their vote? If not, we are going to tally the vote. Madam Clerk.
Mr. Chairman, you have 21 ayes, 0 noes.
21 ayes and 0 noes. I think that's a resounding victory.
Yay.
You are off to calendar and rules as amended, sir.
Thank you.
How about our good friend, Representative Kiesling? I see you down there. Would you like to be recognized on House Bill 743?
Would you please?
Yeah, you are, sir.
Thank you.
House Bill 743. I see a couple of amendments here.
Yes, you do, sir.
Are we going to need both of those?
Let's do.
All right.
I would appreciate that.
Well, motion on Amendment 1, which is coded 4631. Yes, you got a motion and a second. All those in favor of attaching it, please signify by saying aye. Any opposed, no. Amendment 1's attached. Now let's just follow up with Amendment 2.
All right.
Drafting code 5917 is what we have.
That's correct, sir.
All right. Motion and second. All those in favor, please signify by saying aye. Any opposed, no. All right. Representative Kiesling,
All right.
tell us what you'd like for us to do.
Well,
consider.
maybe we'll do our best here.
All
Thank you for that support, members, chairman, and members. All right, let's get started with this. Is regarding or relative to debt resolution, licensure, and regulation. Now, the purpose of House Bill 743 it modernizes the licensure and regulation of debt resolution providers. The bill will assist our consumers with greater transparency regarding debt resolution. Our current law combines regulation of debt resolution companies with credit counselors, which has proved quite difficult. This bill separates the two industries into separate regulatory regimes. It will remove ambiguities and make it easier for our regulators to administer oversight. A little bit of background. Our state was one of the first in 2008 to adopt regulation and licensure of what was known at the time as debt settlement companies, along with credit counselors. Now, most importantly, though, most importantly, debt resolution companies are barred from assessing their customers any fees until there's a semicolon. 1, a resolution on an account's been reached for a consumer with their creditor. 2, the consumer has accepted the resolution. And finally, 3, the consumer has made a payment to the creditor towards the resolution. This makes debt resolution one of the only products in financial marketplace whose providers must deliver the benefit of their services before they're legally permitted to collect. Now, under the provisions of the bill, it reads: the bill requires debt resolution providers to obtain a license before providing these services. However, The bill does include exemptions, i.e. bank employees, attorneys, and then CPAs, certified public accountants. Finally, Mr. Chairman, the consumers must deposit their funds into a FDIC insured accounts dedicated solely to debt resolution purposes. Service agreements must clearly outline the services provided, fees charged, and the role of the licensee as the consumer's advocate. The consumer retains the right to terminate the agreement with the debt resolution company at any time, owing the company only the fees for the services provided. It is a 24-page bill, one that I can't memorize word for word, Mr. Chairman, but with that, I will entertain and I'll try to attempt to entertain any questions, sir.
Thank you for that explanation. Do we have questions for the chairman? Do we have any questions? Sir, that 24 pages must have been very particular because looks as if no one has any questions for you.
Amazing, sir. Thank you.
That's quite the authorship there, Chairman Keesling. All right, seeing no questions, let's vote on this. All those in favor of sending House Bill 743 to Calendar and Rules as amended, please signify by punching that button, either whichever color you prefer. Anybody wish to change their vote? If not, do it now. If not, let's tally them. Madam Clerk.
Mr. Chairman, you have 22 ayes, 0 noes.
A resounding victory, Chairman Keesing. You're off to Calendar and Rules as amended.
Thank you, Chairman and members.
House Bill 772, Chairman Powers. All right, we've got a motion and a second. Chairman Powers, you're recognized.
Thank you, Mr. Chairman. And I come with, on my own volition today, with a sense of false bravado to bring you House Bill 772. It updates the current law to address payments on insurance premium finance loans by electronic means and allows Tennessee and insured to expedite a payment of a loan installment by the preferred payment method. House Bill 772 replicates the provisions from the Industrial Loan and Thrift Companies Act related to payment of loan installments by credit card and other electronic means and a collection of one insufficient funds or handling charge per payment. And with that, Mr. Chairman, I'll be glad to take any questions and renew my motion.
All righty. Thank you, sir. Do we have any questions for Chairman Powers on House Bill 772? Seeing none. Madam Clerk, would you prepare the board for voting? Anybody wish to change their vote? If not, let's tally vote. Madam Clerk.
Mr. Chairman, you have 19 ayes, 3 noes.
Thank you very much. Chairman Powers, you're off to Calendar and Rules as amended.
Thank you, Mr. Chairman and committee.
And since I'm the next up, I'll pass the gavel down to Vice Chairman Brickens.
All right. Chairman, you have House Bill 542. Have a motion and a second. I think the bill has an amendment number.
Yes, sir. Chairman, we need to adopt Amendment 3. It rewrites the bill. It's drafting code 6399.
All right, we have a motion and a second. All in favor of putting the amendment on the bill, say aye. Aye. All right. The bill is amended. Please explain your bill.
Thank you, sir. Folks, I want to appreciate the people in the utility community for assisting me with this reason. You see the on the dashboard, there's quite a few amendments, but I've been open to listening to our utility providers and their associations and their representatives here. I told folks early on that I'm married to this idea, but I wasn't married to the words that got us across the finish line. And that is that what this bill is proffering to you to consider is that utilities should have a pathway for customers, and in this case, because it's system improvement, those are typically developers, and this sets up a process by which utility companies are required to allow the choice of the company doing the install or a private installer. Reason is that in high growth areas, sometimes these utilities are not staffed. You have huge delays on projects. This will provide a uniform way for this to be done. It sets bars that have to be met, but it does provide protection in those utilities in the fact that they have to provide an approved list of people who provide these services. They can require bonding. They do have to inspect and accept the improvements, and and not only that, they can require for a year warranty on the work, but after they accept it. So that's what this bill does. It's standardizing what many utilities across the state already do. There were some holdouts, but working with everybody, I think everybody was satisfied with the language that we came to in this bill. And so I'd entertain any questions or do my best to answer them.
Well, thank you, Mr. Chairman. Any questions to the chairman on the bill? We'll call the question, seeing no questions. So let's vote on House Bill 542 as amended. Clerk, would you prepare the board for voting? Has everyone voted? Please close the board and announce the results.
Mr. Chairman, you have 18 ayes, 3 noes.
All right, the bill 542 passes and goes on to finance. So, Mr. Chairman, congratulations.
Thank you, sir. All right, folks, I know that Representative Hardaway, for what purpose?
Mr. Chairman, just to make note that I ran back over here just to cast a vote on your bill, sir.
Well, I appreciate that. I have to say that I wish it would have been a better vote in my mind, but I understand reasonable people can disagree. I know, I see that. I understand that and I appreciate it. Folks, got good news for us. Next week should be our last meeting. We're going to try to get banking and consumer finance closed up this afternoon. That's our endeavor, and we hope to be back here for the closing episode. It'll be a cliffhanger, I promise you. So the highest rated, we think these ratings should stay solid throughout the rest of this week. So anyone, unless there's any more business to come before us, we are adjourned. Mm-hmm.